The matter before the court this afternoon is the case entitled Tammy Wood v. Russell Wood, case number 24 AP 237. Representing the appellant, Russell Wood, is attorney Mark Namath. Representing the appellee, Tammy Wood, is attorney Jacob Oblak.
All right, thank you. Appellate counsel, please identify yourself and your client, and then you may proceed. You have 5 minutes.
Thank you, Your Honor. May it please the court, Mark Namath for the appellant. If possible, I'd like to reserve 2 minutes for rebuttal. Your Honors, the case at hand today is the issue is primarily whether this court will uphold the ruling in Grant v. Grant, which holds that where another state issues a divorce and has personal jurisdiction over both parties, it is within its right to retain the opportunity to determine alimony, and the other state, or in this particular case, Vermont, loses the ability to determine alimony. My position is that based on Grant v. Grant, the Vermont court lost its jurisdiction to determine alimony after June 26, 2020, when the Louisiana court's decision was entered. And quite frankly, at that point, Vermont continued in its process, subject to motions for dismissal and our clear reservation, the issue for appeal, which is now before the court. Essentially, the argument that there is a divisible doctrine available, a divisible divorce doctrine, doesn't hold because the court in Louisiana always had personal jurisdiction over the parties and never made a determination that it lacked jurisdiction. And when the final hearing or the final determination in October of 2022 was held by Louisiana, at that time, Louisiana had personal jurisdiction over the appellant and was able to move forward. At that time, the Louisiana court basically entered a dismissal on the basis of Liz Pendens, finding that the Vermont court retained jurisdiction over alimony, and that simply wasn't correct. And our court's decision to proceed on the basis that the Louisiana court didn't have personal jurisdiction was never determined by Louisiana court, but quite frankly, the Vermont court made some determinations. I believe it was Judge Garrity who had made a determination that the Louisiana court did not have jurisdiction because there was only an 18-month period. There was an 18-month period that had expired and basically rendered Louisiana without minimal contact. And also the issue then was the Vermont court found that there was no personal property, no real property still in Louisiana, and there still was. And that is essentially the essence of my argument. I'm now out 3 minutes. I'd like to pause and save my final 2 minutes for rebuttal.
All right, counsel. Counsel for the appellee, please identify yourself and your client. You may proceed. You have 5 minutes.
I appreciate it, Your Honor, and may it please the courts. My name is Jacob Oblak, and I represent the appellee, Tammy Marshall, formerly known as Tammy Wood. If at any time you can't hear me, please let me know. I know I'm having some issues and I had a hard time hearing Your Honor just a second ago. So please let me know. To respond to the appellant's argument regarding the divisible divorce doctrine, we believe that the Vermont court here properly exercised its authority to determine personal jurisdiction as far as both parties in Louisiana. And that the cases we cited in our brief from Vermont law do support that proposition that the Vermont court was absolutely within its jurisdiction and authority to hold a fact-specific hearing on domicile. And domicile is a fact-specific analysis. No one fact, as the appellant focuses on one fact, 18 months. He focuses on one fact here today, but domicile is a fact-specific analysis that is entrusted to the reasonable exercise of a trial court's discretion. And we believe that's what happened here. And we also furthermore believe that the appellant had an opportunity to challenge personal jurisdiction in Louisiana and had an opportunity to challenge what he now brings to this court as in his view, that Louisiana was wrong. The Louisiana court was wrong in its ruling that Vermont had jurisdiction to, excuse me, to address alimony and property division. But he had a remedy there. He could have appealed that. He chose not to. So from our view, he's attempting to collaterally challenge the Louisiana holding here, which is improper. And the court should keep in mind that this is a long-term marriage where husband and wife primarily lived in Vermont for the large portion of the marriage. The last 4 years of it, 2014 to 2018 in Louisiana, and then wife came back. No one disputes that Vermont had, or at least not today, no one disputes that Vermont had personal jurisdiction over both parties and could proceed with its divorce action here. At issue is, of course, husband who waited 7 months into the Vermont proceeding and then filed in Louisiana. And it appears, again, I don't practice in Louisiana, but it appears from a review of Louisiana law that Louisiana trial courts, when they consider a divorce case, adjudicate the in rem status of a divorce, the divorce itself, before they do anything about the property or the alimony. And Vermont, by then, of course, had already issued an alimony order. And so when Louisiana did exactly that, we don't believe that severed jurisdiction or rendered the divisible divorce doctrine inapplicable. Rather, even based on the case law cited by appellant, including other case law, Poston v. Poston here in Vermont, and Eston v. Eston at the U.S. Supreme Court, Vermont was well within its jurisdiction to continue with the remaining portions of the divorce. Grant is inapplicable here because, again, we don't view the trial court's decision as trying to create whole cloth a freewheeling alimony action. We agree that's not what's happening, and it shouldn't happen. But here, Vermont did have jurisdiction pursuant to a valid divorce, and as such, it exercised its discretion here in determining that Louisiana did not have personal jurisdiction. It basically is giving effect to the Louisiana order, which we believe it had to under the full faith and credit clause of the U.S. Constitution, and then it thereafter adjudicated the remaining issues. If there are no further questions, I would stand on our briefs.
All right, I don't see any additional questions. How much time does the appellant have remaining?
Appellant has 2 minutes and 2 seconds remaining.
All right, counsel.
Thank you, Your Honor. Your Honor, the Vermont court made a determination after it lost jurisdiction to proceed under the Grant decision. The Louisiana court had the ability to move forward as demonstrated by the appellant's motion for modification from a determination of alimony, and he did not challenge the decision because it wasn't his it wasn't incumbent on him to do so, because effectively the court declined. But the Grant holding stands for the idea that where another court has personal jurisdiction and authority, it may proceed, and the other court, in this case, Vermont, cannot proceed. And Your Honor, the bottom line is this. They made a decision on Liz Pennins. There was no question that there was personal jurisdiction. The Vermont court made a determination about personal jurisdiction over a Louisiana resident who had real estate there, and the court, in its own findings, said there's really no impression that there's real estate there that impacts this. And the court also relied on this 18-month window. I hope this court recognizes that my client essentially erred and filed a motion for continuance and effectively waived personal jurisdiction. All other things being equal, this court would have never had jurisdiction. She'd been out of Vermont for 5 years, unlike the appellant who had been out of Louisiana only 18 months. It's just not fair. And again, Grant really does matter. It does have a holding, and the divisible divorce doctrine only applies when the other court, in this case, Louisiana, does not have personal jurisdiction. At the time that the Louisiana determined the petitioner or the appellant's petition for property distribution, they had personal jurisdiction. There was no question about it. And it therefore could have proceeded, but for a challenge that it didn't, that the appellee made.
All right, and thank you very much for your argument, counsel. Your time has expired.
Thank you, sir.
Bailiff may call a conclusion of the hearing, please.
The next hearing for